Legnaturalistic law as a basis of legal regulation of safe society development. The purpose of modern civilization is its secure development, without which it is impossible to exist in the future. Activities in this development begin with its modeling, which is carried out through the legal regulation of this process. The basis of legal regulation is law. Without his correct understanding, it's impossible to build an effective system of legal regulation of the safe development of society. Along with this, the existing concepts of law and the practice of their implementation are not based on its essence, substance, principles. The legnaturalistic concept of law, which is proposed in the article, is built on these basics. Key words that were used during article presentation: patterns, types of patterns, legal regulation, legnaturalistic law, safe development society, and types of laws of safe development of society. From the point of view of most specialists, the purpose of modern civilization is seen as its sustainable development. In our opinion, it's not entirely true to talk about the sustainable development as the goal of modern civilization. First, any development is sustainable because development is impossible without sustainability, and only jumps leading to uncertainty or regression are possible in that case. Secondly, any development is impossible without ensuring its safety. And thirdly, development involves an increase of development characteristics that do not always lead to a positive security result. For example, the development of physics and chemistry led to creation of weapons of mass destruction, which can interrupt all the development of mankind. Therefore, from our point of view, the purpose of modern civilization is its security development. This development is impossible without its legal regulation, which creates a certain model of this process. Legal regulation is a purposeful, systematic, effective activity to streamline the life of society. It can be noted that the above-mentioned types of law understanding focus on certain qualities of law. The natural type says more about the formation of law, positive about the systems of law, sociological about the realization of law, and psychological about the consciousness. From our point of view, in any type of law understanding there must be a legal origin that makes these understandings legal. This origins concept connects the type of law understanding, rejecting the wrong or illusionary, non-existent illegal elements. Any law understanding should be based on the ancient Rome axiom: the law is the embodiment of goodness and justice. This is the beginning that unites all types of law understanding. If justice is not paramount in doctrine, it's not legal doctrine, and this is the quality of law that is the basis for ensuring the safety of society. Thus, every type of law understanding has the right to exist, but still there must be a basis that unites them. Such a basis can be a legnaturalistic understanding of law, in which the substance of law is its foundation, the primary source, where origins are the patterns of the existence of nature, society, humanity, the reflection of which should be the law. From our point of view, according to the legnaturalistic understanding, law is a system conditioned by patterns of existence of imperative, formally defined social norms that embody freedom and justice, which are issued by authorized structures to regulate the behavior of people. The essence of legnaturalistic approach is the idea that the right is generated and is a reflection of the patterns of existence, conceptually integrates rational elements of existing areas of law understanding that consists of natural, social, psychological, legal patterns, such as schools of natural law, sociological jurisprudence, psychological theory of law, and legal positivism. The humanity considers such a law understanding in the universal system of the world order. which creates harmony in society and in its relation with other structure of existence. That is a creation of justice world, which is the main sense and purpose of law. We believe that there are substantive and subsidized laws that are not singled out by specialists. For example, substantive laws are the basis for the existence of social phenomenon. They condition its essence and can be foundation of this phenomenon. Therefore, they are imperative. They could be given the following definitions. These are integral, main, primary, natural qualities of the phenomenon. Subsidized laws arise on the basis of substantive, conditioned by them, their detail and specification, in accordance with certain conditions. Therefore, they are dispositive. It should be noted that the laws of nature are the basis for the substantive and subsidized laws of society. From our point of view, the security of society is the existence of society in accordance with the patterns of its human being. They can be classified as follows. According to the objects of safety, patterns of natural objects, patterns of social objects, patterns of technogenic objects. By scale, cosmic patterns, planetary global patterns, regional patterns and national patterns, and local patterns. By volume, patterns of the system, patterns of system elements. By significance, substantive patterns, subsidized patterns. By nature, structural patterns, functional patterns. By commonness, its general laws, special laws, and private laws. There are other types and subtypes of patterns. These type of patterns can be detailed into other patterns. But still it should be noted that it is impossible to form a harmonious, safe society without the knowledge of social patterns. From our point of view, the purpose of modern civilization is its security development. This development is impossible without its legal regulation, which creates a certain model of this process. The basis of legal regulation is the right on which the effectiveness of legal regulation of the security development of society depends. Every type of law understanding has the right to exist, but there must be a basis that unites them. Such a basis can be a legnaturalistic law understanding, where the substance of law is its foundation, the primary source, where the beginning is the patterns of existence of nature, society, humanity, where the law should be its reflection. And we should be noticed that laws are not strict constants, that is, they allow variation within certain limits, less in imperative laws and more in dispositional.